Good morning, everybody. My name is Marty. Oh, I guess I should turn on my camera, right? Good morning, everybody. My name is Marty Mascari. I'm with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center. Welcome, everybody, and Happy New Year. Both of the organizations that I'm with are under the North Central Texas Council of Governments. I'm a contractor with them, and we are blessed here to have our partners with Heyman Hogue here today. They've invited other speakers with Ardent Hospice and with Dignity Memorial. And so today we're going to talk about end stages, what you should know about, I'm just terrible because what you should know about legal hospice and final arrangements. If we can move to the second slide, I'm going to talk about CEUs real quick and then we'll get going. For those of you that are I'm going to let Sheila do this. Sorry.
Well, good morning. Good morning, everyone. If you've never joined us before, to get your CEU credit, which we do offer for nurses, social workers, assisted living managers, and licensed professional counselors of all types, and nurses of all types too, by the way. It's very simple. You're going to be sent 3 things. Okay, when Marty follows up, you're going to be sent 3 things. You're going to be sent a disclosure statement that says that all 3 of us do this for a living. And you understand that. However, all we are doing today is educating. We're not trying to sell you anything, including our services. We're trying to educate and answer your questions so that an educated public is better for your families and for your patients. Okay. But then you also get a sign-in sheet and an eval form, just like you do with any other CEU. Please fill those out, send those back to me, Sheila at Heyman Hogue, and I will be happy to send you your credit, your certificate of credit. And it's 1.5 hours that you will get today. Okay,
nice.
Thank you.
Nice. In addition to Sheila's information, we have a Google survey that should pop up when you close out of Zoom today, but you'll also receive that link in the follow-up email. I realize some of you work for companies that have pop-up blockers, but the Google survey, we ask that you complete that as well. That really helps us to report back on our goals and objectives we set forth when we applied for the funding to host these webinars. So please help us with that if you would. I'm going to turn it over to Sheila and let Sheila introduce our speakers.
We're going to go in an order today as what you would, or what I would assume this should go in. And we're going to start with hospice and palliative care. I want to introduce my friend and a trusted colleague that we refer from Heyman Hogue, which is Jeanne with Ardent Healthcare. Jeanne.brosseau.
Good morning, everyone. Thank you for joining us on this webinar and for a very important topic. I'm going to be discussing hospice and palliative care today. Thank you. When I talk about hospice, really it's the next level of care. It is a benefit that you have worked for and earned, especially with Medicare benefits. So hospice is the level of care that focuses on symptom management and quality over quantity when reaching the end of life's journey. The hospice team is medically directed and consists of nurses, bath aides, social workers, chaplains, and volunteers. The criteria for hospice. To be eligible for hospice care, patients must have a diagnosis of a life-limiting illness or terminal disease with life expectancy of 6 months or less, as well as a desire for comfort care rather than curative. What services does hospice provide? Any medical equipment that the patients need, including oxygen, wheelchair, walker, hospital bed, over-the-bed table, potty chair, anything that the patient needs. Medications directly related to the hospice diagnosis. That does not mean that all other medications are stopped. It means that hospice covers some, and the rest of the home medications that are going to be continued are still covered under your prescription drug plan. Any supplies that our patients need. any incontinence supplies, pads for the bed, and so on. Nurses, bath aide, social worker, chaplain, and volunteers, that is your team. We have staff available 24 hours a day to answer questions. That's with any hospice company that you choose. Spiritual care is also very important, and also emotional support for both the patient and the family. The work of the hospice team. The team attends to the emotional, psychosocial, and spiritual aspects of dying and caregiving, and teaches the family how to provide care. We advocate for the patient and family and provide bereavement care and counseling. Where is hospice provided? Any place that the patient calls home, which can be a nursing facility, in the hospital, hospice resident or unit, correctional setting, homeless shelter, again, wherever they call home. How is hospice paid for? It is a Medicare benefit. It is a Medicaid benefit. Most insurances and HMOs cover hospice care. It's also can be paid for by private pay, and sometimes a combination of all of those. Moving on to palliative care and how palliative care is different. So palliative care is a specialized medical care for people living with a serious illness and need symptom management. The patients can seek aggressive treatment for their illness while in palliative care. Who does the team consist of in palliative care? Consists of specially trained professionals, including doctors, advanced care nurse practitioners, nurses, and social workers. So what is the difference there? I know that's a big question. So palliative care provides symptom management while the patient is seeking treatment for a serious illness. There is no time frame for how long a patient can utilize these services. Hospice focuses on providing quality of life when treatment is no longer working or wanted. Palliative care is billed under Medicare Part B, while hospice is billed under Part A. Yeah, anybody have any questions?
Please put your questions, any questions you might have, in the chat or the Q&A. We don't open the mics just because, you know, we've got almost 200 people on this morning. So, but please, and you can, if you think of questions, while the next presenter's presenting, please add those to the Q&A, and we can also address those at the very end. But if anybody has any questions, you're more than welcome to put them in there now.
So Marty, are we going to address some questions at this point, or are we going to just hold off and do them all at the end?
You know, that's really up to y'all. They, you know, each of the presenters had a question, you know, a slide at the end of their presentation for taking questions, and so I just left them in there. But there's a couple of questions here that we'll throw out if we could, just real quick. Are there any hospice agencies that provide 24-hour bedside care?
24-hour bedside care is a level of service that has its own criteria, and that's called continuous care. Continuous care is brought in when the patient has a symptom that cannot be managed with scheduled medications in the home. It's a crisis situation. So respiratory crisis, pain crisis, severe agitation. A nurse comes in and evaluates for continuous care. So continuous care is where a nurse is put at the bedside. That starts at 8 hours a day, and it continues until the symptoms are managed. So that can be 8 hours, 12 hours, 24 hours, 72 hours. It's all based on getting the patient comfortable and making sure that their symptoms are managed. So it's not round the clock 24-hour care, but there are private sitter services that can be brought in for that if you need that, and that's private pay.
Jeannie, why is palliative care billed under Part B and hospice under Part A, Medicare part?
So hospice has always been billed under Part A, under those services. The Part B Medicare is when you go to doctor's offices, when you go to the hospital, it is a different medical need. So the ICD-10 codes that palliative care bills under is for transitioning, critical care management. So those ICD-10 codes are under the Part B.
Okay, what kind of illnesses may be covered under palliative care?
Everyone, any illness that the patient has. It just is, it's extra care at home, extra eyes, and it has that advanced care nurse practitioner communicating with the patient's physicians.
Okay, what about if they had ALS or something like that?
So palliative care can come in for ALS. When ALS reaches the point that it's end stage and it is appropriate for hospice care, then palliative care backs out, hospice care comes in.
Okay. Okay. All right, we've got a whole lot more. So let's go on and do those at the end. If we
Okay.
keep, just hang in there, everybody, because we will address because there's a lot more questions, which I
That's
figured there would be.
Perfect. That's
So,
great.
okay. All right. Now our next speaker is my boss, the founding partner of Heyman Hogue, Fred Heyman. And he is the perfect person to do this because of his story. He's experienced a lot of these things. And we deal with these on a day-to-day basis. So without any further ado, my boss, Fred Heyman.
Well, thank you, Sheila. She always introduced me as her boss, but we all know who really the boss is. Just because I sign the checks doesn't mean I'm the boss. But I do my best. So yes, I'm Fred Heyman. I am an attorney. Please don't hold that against me because I probably don't like attorneys more than you don't, because I have to work with them all the time. But I've been practicing law about 25 years. I was a police officer out in El Paso, Texas. Those of you all from El Paso. I was a police officer out there for 5 years before I went to law school. And now I do exclusively estate planning and elder law. I've been doing that for about 15 years now. So today we're going to talk about all of the important documents that everybody should have, especially leading up to end of life. One of the things that just breaks my heart is when I have clients call me when it's too late. Families call me when mom and dad have gotten to the point physically or mentally where they can't sign any documents, and now they find themselves in a position where they can't help them, and they're getting questioned by financial institutions, they're getting questioned by healthcare institutions because they don't have the documents in place that they need. Now, one of the things that is so important about these documents that people really fail to do is you need to put these documents in place when you don't need them. And that's the thing, is you've got to get them in place. And this is why I say these are documents that everybody over the age of 18 needs. Now, under the age of 18, parents can make decisions for their children. The minute the child turns 18, the child is no longer a child, it is now an adult, and the law sees them as an adult. So everybody 18 and older needs these documents. Now, an 18-year-old going to college isn't the same as the person that is 50 and has $1 million estate. So documents need to be tailored to the people that they're done for. And that's what we do. We have all different packages that we offer people depending on where they are in their stage of life and what they need. The problem with these not having documents in place is you're not going to have people that you trust, that love you, that are part of your family, either close friends, whatever, that can make financial and healthcare decisions for you when you can't make them. And so issues at hospitals come up, issues at mortgages and rent come up, issues with your bank, issues with student loans, issues with your employment and employment benefits. All of those things that we take for granted because we're dealing with it on a day-to-day basis, you can't make because you don't have, you're not capable of making them because of either a physical or a mental incapacity. And you have not appointed somebody to make those decisions for you. So can you imagine being at a point where somebody isn't able to manage your money for you or pay your bills? Somebody isn't able to talk to your bank or investment company to move money to be able to take care of things. They can't transfer funds. They can't consent to medical treatment. They can't make medical decisions for you. They can't obtain your medical information. To me, the father of 2 children, I've got a 21 and a 17-year-old daughter. My 21-year-old daughter is now in her 3rd year at the University of Alabama. And I can't even imagine her going to the hospital or something happening to her up in Tuscaloosa and me not being able to talk to the medical professionals because I don't have a medical power of attorney for her and I haven't signed a HIPAA form. She didn't sign a HIPAA form. And therefore I'm calling and saying, how is my daughter? And they have to tell me I can't talk to you because she's an adult and she hasn't signed these documents. So the simplest things become nightmares when these things aren't in place. Can you imagine going to the emergency room or calling the emergency room and having them tell you, we can't talk to you about this because there's not documents in place that give them permission to do so? Can you imagine not having somebody with the ability to make decisions for you in a medical emergency? Because if you can't make the decisions, then you either have appointed somebody to make decisions for you or the medical professionals get to make all the decisions. And yes, I trust our medical profession 90% of the time, but there's a few out there that make medical decisions based on what insurance coverage you have, based on what they're going to get paid. And so we don't want to take that chance. We want to be able to have people in place that we trust that will make the best decisions for us in those times of need. So medical decisions, medical treatment decisions, and obtaining information on medical records. Financially, paying bills, talking to the mortgage company, talking to landlords, being able to talk to the utility companies. The utility companies really hits home with me, and Sheila touched on it, my story. In 2007, I almost died. I was 42 years of age. I was a trial lawyer at the time, and I was fighting a disease called ulcerative colitis. I'm sure most of you all in this call know what that is. But ulcerative colitis is a severe autoimmune disease that attacks your colon, your large intestine. I had been fighting that disease for 5 years while working 60 to 80 hours a week as a trial attorney. I wasn't going to let this little disease hold me back, so I was continuing to go 150 miles an hour in my life. And over a 5-year period of them trying everything on the market at the time, my condition got worse and worse and worse. And at the end of 2006, the doctors came to me and said, we either remove your colon or you're going to have colon cancer. Not remove a part of my colon, remove all of my colon. And so at that point in my life, I was such an arrogant, a matter of fact, trial lawyer that all I cared about was how long am I going to be off work? And the doctor said, well, you're going to be off work a minimum of 3 months. And I'm thinking to myself, okay, that means I'll be back in 6 weeks because I control my life, not this disease and not anything else. Well, if you ever want to make God laugh, tell him your plans, because God had different plans. The doctors in my situation messed up and my intestines ruptured. I was in critical condition for 10 days. I almost died. I should have died. I was in the hospital 37 days the first time. I was in and out of hospitals and in and out of surgeries for over 8 months. I was out of work for over 8 months. I had 6 surgeries. The last 2, they had to ship me up to Cleveland, to the Cleveland Clinic, to put me back together and save my life. It was the worst time of my life, but it was the best time of my life because it made me realize I had gone to law school for all the wrong reasons. I had gone to law school to make money. And for 10 years practicing law, I did. And 8 months later, I was broke again because of medical bills and not being out of work and having to pay all our bills. People at our church were giving us money to help us pay our mortgage. But during that time, while I was sick, there was a time when my wife came in and she said, they're going to turn the electric bill off because you haven't paid the bill, because I took care of everything. And I said, well, talk to them. She said, they will not talk to me because your name is on the bill. My name is not on the bill, and I don't have your power of attorney to talk to them. And I'm laying in a hospital bed full of tubes, wondering, they won't talk to you to take our money? No, they wouldn't talk to my wife. So I'm having to try to get on the phone in the hospital in the middle of all this to talk to a utility company so that we can pay our bill and not get our electricity turned off. She needed to apply for a disability policy that I had and couldn't, because I hadn't signed a HIPAA form because of emergency situations. I had not signed all the hospital forms that people normally sign. So the simplest things have become absolute nightmares, because guess what? I didn't have any documents in place. I was 42 years of age. I was an attorney for a living, and I had no documents in place. Why? Because the same reason 70% of the population doesn't have documents. I lived in the mentality of, it will never happen to me. I'm only 42. I've got plenty of time. I'm not going to ever get sick or die. And I'm an attorney, so I think I know more than everybody. So I'll just take care of things. It was an absolute nightmare. And that changed the direction of my life. And that is why I do what I do now, is because I don't want anybody to ever go through what me and my family went through. I used to say what I went through, I didn't go through it though. I was in a hospital bed trying to get well while my wife was trying to fight all these things and take care of things that she couldn't take care of because I didn't put my documents in place. So this does mean a lot to me, and I really can't emphasize enough how important it is that you do these things so that your family can take care of things and make the decisions they need to. I mean, they do the simplest decisions like responding to jury duty or taking care of traffic tickets or passports or driver's license or car registrations. I mean, the things that we take care of on a day-to-day basis that you cannot take care of if you're incapacitated and you don't have documents in place. So the fact is, no documents, no authority. So what do you need? What are these documents that everybody should have? The first one, everybody's heard of, the power of attorney. It's often called the statutory power of attorney, the durable power of attorney, but it's a power of attorney for financial purposes. Now, one thing I can't emphasize enough is a power of attorney is not a power of attorney is not a power of attorney. So the worst thing that any of you all could ever do, or any of you all could ever recommend, is to get on the internet and do a power of attorney, because you do not know what you're getting when you get on the internet. A power of attorney has to be drafted well enough to where the people you give it to have no reason to deny it. Because every time you go to a financial institution, you're dealing with that financial institution's rules, not just the law, but their rules. Bank of America has different rules than Chase, has different rules than Wells Fargo, has different rules than Fidelity and Liberty Mutual, and all these financial institutions have their own rules. So you really need a power of attorney that is comprehensive enough to deal with any situation. I've seen powers of attorney that were 3 pages long. Our powers of attorney are typically 10 to 15 pages long. Some of our powers of attorney are even longer than that because of the assets that our clients hold. So you have to have a power of attorney well drafted, well written, because you never know if it's any good until the time you use it. The second document that's just as important is the medical power of attorney. That is where you're appointing somebody to make medical decisions for you if you can't make them. As long as the doctors can talk to you and you're mentally and physically able to answer questions, they have to talk to you. But the minute they can't, then they need to have somebody to fall back on that you've appointed to give authority to make medical decisions for you. Now, these are medical treatment decisions, not necessarily end of life, pull the plug decisions. That's why you need the next document, which is called the Advanced Medical Directive. It's also called the Directive to Physicians in some states. That's what Texas calls it. It's also called a living will in some places. Now, I don't like the term living will because it has nothing to do with living and it has nothing to do with your will. So Advanced Medical Directive is a better term, but you have to see what your state calls it. But this is the document that where you decide if the doctors have tried everything and there's no more hope, do you or don't you want to be kept alive on life support? Now, this is different than a DNR, do not resuscitate order. Now, people always tell me, well, I've got a DNR and it says that they have to keep me alive until there's no hope. Well, then that's not truly a DNR. So every document is only as well as it's written. So some DNRs are written to have language in it for advanced directives. Some advanced directives are written to have DNRs in it. But a difference between an advanced directive and a DNR is a do not touch me order. So my mom, who is going to be 91 in about 20 days, has a DNR. She does not want to be brought back if she has a heart attack. She does not want CPR if she loses consciousness. So a DNR says, don't touch me no matter what. An advanced directive says, yes, I want you to treat me. I want you to bring me back. I want you to make me well. I want you to do everything in your power to take care of me. But if you've tried everything and now there's no more hope except for keep me alive on a machine or let me go, then the advanced directive is where you decide while you're well, do I or don't I want to be kept alive on life support? That is a great document because it takes the decision away from your family so that they don't have to live the rest of their life wondering if they made the right decision. The next document everybody's heard about, and that's HIPAA. Everywhere you go, you sign a HIPAA form. The problem is, though, when you go to a doctor's office or you go to the hospital and you sign a HIPAA form, you are signing a HIPAA form only for that location, and it's written in their favor, not in your favor. So we always recommend that you do a comprehensive HIPAA form that's good anywhere. My HIPAA form says, no matter where I go, no matter what hospital I go to, no matter what facility I'm in, I give these people permission to get my medical records and my medical information and medical treatment information. The next document is the Declaration of Guardian in case of future incapacitation. This is a form that says, if I become totally incapacitated, who do I want my guardian to be? So I'm deciding on my guardian rather than the courts deciding or whether than the family fighting over it. This form allows me to name my guardian, but it also allows me to say who I don't want my guardian to be. So I know everybody out there has people in the family that are troublemakers or problems causers, or they're just not capable of doing the duties. Instead of the family fighting over it, this document says, I want this person, and this person to be my guardian, and I don't want this person to be my guardian. So this form is only used if we need a guardianship. A guardianship is a legal process that has to go through the courts, but this is a document that we give the judge when that process takes place so that we make the process more streamlined. So there are a few misconceptions when dealing with these documents. The first one I see, which all three of these misconceptions, I know you guys out there are going to say, that's really stupid. I can't believe people think that. But the first one is, can these documents be signed when I'm legally incompetent, when I'm incapacitated? And I get that call all the time. I need to bring mom in to sign a power of attorney. Mom just got admitted to memory care. She's got severe Alzheimer's, and I need a document so that I can take care of her. And I have to tell the person, I'm sorry, if mom has Alzheimer's to the point where she's needing memory care, most likely she doesn't have the mental capacity to sign a document. We're out of luck. You've waited too long. So instead of a $250 document, we're now going to have to do a $10,000 guardianship proceeding to give you legal authority to take care of mom. I hate that discussion, but I have it all the time because people wait till it's too late. If you need the documents, it's too late to sign the documents. You have to have the documents before they are needed. The second big misconception I see all the time is that one size fits all. okay, I can get on the internet, I can download these documents, I can fill them out, and I'm good to go. The reality is the internet is not regulated. Therefore, if you sell documents over the internet, there is nothing that is regulating you. You know who regulates me? The State Bar of Texas. You know who regulates nurses and social workers? We all have regulators. The internet does not. And in fact, they've actually gotten to certain legislatures. In Texas, there's a law that says if I am selling these documents over the internet, I am not practicing law, and therefore I do not have to comply with anything an attorney has to comply with. I am doing nothing more than selling a product. And if that product is bad, oh well, good luck suing me, because I have pretty much immunity because I'm selling it over the internet. I've had so many bad case scenarios, and people will tell me, oh, you must hate these internet providers like LegalZoom. Nope, I love them because they make our firm a lot of money when we have to clean up the mess because they're terrible. But I hate them because they're selling people cruddy documents. You need to have them done by somebody that knows what they're doing. So don't go to the internet. Don't go to Office Depot and get something off the shelf. Don't go to Susie Orman or people like that. Don't even just go to any attorney. I've had people say, well, I'm going to go to my divorce attorney. I'm going to go to my criminal defense attorney that took care of a DWI for my nephew. No, you want to make sure these are done by somebody that knows what they're doing. The last big misconception is one of the silliest of all, is that these documents survive death. Well, Dad just passed away, and Dad, we need to pay Dad's bills, so I'm going to use Dad's power of attorney to get to the bank account and pay his bills. No, you're not. These documents are living documents. They are only good while you're alive. The minute a person dies, the documents die. You need living documents, you need death documents. A power of attorney cannot be used after death, and if it is used after death, you are committing fraud and could go to jail. You do not want to do that. So these documents are only good while the person's alive. So there's potential problems that we have with documents if they're not done properly. Do they give all the necessary information that's needed to be able to comply with the financial or the healthcare institutions? Is it legally valid? What does that mean? Is it signed properly? Is it notarized properly? Is it witnessed properly? Does it have the components in it that the law requires it to have? Is it current? I get this one all the time. People saying, well, I've got my documents. Once I've got them, I'm good to go for the rest of my life, right? No, you want to make sure that you review these documents every 3 to 5 years. I've had clients call me and tell me financial institutions have refused to accept a power of attorney because it's older than 5 years old. And they'll tell me, well, does that mean the document's no good? I'll say, no, the document's still good, but it's not good to that financial institution, and therefore it's not good to you in your situation. So you want to make sure you keep these documents current and up to date. We find that we make 20 to 30 modifications and changes and additions to our documents every single year. So after 5 years, you're looking at 100 to 200 changes that have been made because of law changes, because of legal strategy changes, because of financial institution rule changes. So you want to make sure that your documents always stay current every 3 to 5 years. Does the document import lack of authority? Does it give the person the authority to do what they need to do in the situation that they're in? Does it give the proper details to the situation that they're in? Does it have the requirements of the state? This is a huge one. You need to have documents from your state of legal residency. If you live in Texas, you need to have Texas documents. If you live in Colorado, you need to have Colorado documents. Every state is different. My uncle lived in Wisconsin. He was dying of cancer a few years back, and I went up to see him. And of course, the first thing I asked him, do you have your documents? Of course, he didn't. So he asked me to do them. I said, I can't. I'm not a Wisconsin attorney. But I got him a Wisconsin attorney. They drafted the documents. Out of courtesy, that attorney sent them to me to look at. I called that Wisconsin attorney and I said, I'm going to have to trust you because these documents don't look anything like our Texas documents. So I have to trust that these are Wisconsin legal documents. You have to have them in the state that you live in. Is the document ambiguous? Is it clear? I guarantee if you take a document to a financial institution or a healthcare institution and they can't understand what the document is saying, they're not going to accept it. It's got to be very clear in the authority that it gives. So from there, we go to the death documents. Everybody knows about the biggest death document, the last will and testament. Everybody should have a will. Why? Because in every state, if you don't have a will, you do have a will. It was written by your state. And I guarantee you don't want the will that the government has written for you. So you want a will that you write that says what you want done when you pass away. I get people all the time that don't want to do a will because they don't want to face the fact that they are going to die. I'm sorry to tell you, but 100% of the time, everybody on this video right now is going to die. Nobody can get out of it. So why not put things in place for that day? That day may be tomorrow. That day may be when I'm 115. I don't know. I just want to make sure I have things in place. So the biggest death document is the last will and testament. There's others that we do, like designating a representative to carry out your funeral arrangements. We do anatomical gift forms for people that want to donate organs, but the will is the big one. But again, a will has certain limitations. So I always tell people that they want to think about that when they're doing it, because a will doesn't have any lifetime benefits. It's not any benefit while you're alive. And again, like I said, if you don't have one, the government has one for you. But it does allow you to decide who gets your stuff. Who are you going to give your stuff away to when you die? Who's going to be in charge of that? Who do you trust to divide your assets up? You can assign a guardian for minor children in a will, but I do not recommend it because a will has to go, most states, a will has to go through probate court to be valid and authenticated. And if you've named a guardian for your children and there's a tragedy and mom and dad are lost, for instance, those children may be subjected to child care with the Child Protective Services. I've seen it as a police officer where that happened, where the Child Protective Services says, yeah, I understand there's a will. I understand it appoints a guardian, but until the judge accepts that will and appoints that guardian, these children are going to come into our care and go into temporary foster care until that's decided. That is a horrible way to plan. There's other ways to plan for guardian of your children through a trust, etc., that is much better than doing it through a will. You can outline your funeral arrangements in your will, but what good is that? Because again, it's not good till the judge accepts it. And by that time, the funeral's over. So the funeral happens very quickly. You can do what's called a testamentary trust within a will. And that's a trust that says, when I die, I want this trust to go into place. I don't recommend testamentary trusts because to me, they're not any, why would you do a trust that you get no benefit during life and you're putting the burden on somebody else to set it up after you die? If you want a trust, do a trust. And we're going to talk about to me, the best planning tool you can ever consider is an revocable living trust. That's different than a testamentary trust. And again, it's triggered upon death, and it's not good until the probate process is gone through. So one of the best ways you can pass on your legacy is through a living trust. I'm not going to go into depth on this. This is a whole hour plus presentation I can do on living trust. If anybody after this call wants to learn more, reach out to us. I can email you some information, some other webinars we've done. I'll be more than happy to be a resource and answer questions. But a living trust does some really, really great things. One, it avoids probate. It helps us pass our assets outside of court jurisdiction and government intervention. I always tell my clients, do you want to keep the courts out of your life and the government out of your life? You want to look at a living trust. It allows us to do things like avoid guardianship if it's properly drafted in case of incapacitation. It allows us to do tax planning if we need to take tax planning. So there's so many things you can do with a living trust that you cannot do with any other document. And again, a living trust is not one size fits all. Everybody that comes through our office gets designed a trust for their specific situation. Because my daughter, who is 21, has a trust. She doesn't have a whole lot yet. She's still in college. She, got a bank account, but I put a trust in place for her. Now she wants to go to medical school. I'm praying. And if she goes to medical school and then she starts her medical career, I'll do a whole different trust plan for her, because now she's going to be getting a house. Now she's going to be starting a family. Now she's going to be having children. So you want to have the living trusts designed for what you need them for. So a living trust is one of the greatest things you could ever look into. So I'm on my questions slide. So I'm going to move forward, and we're going to hold our questions until the end, because I know there's typically a lot of questions in this area. So we'll save those to the very end. So I will say thank you. You will have my information when this is over. So please, anybody, no matter where you are, even if you're in other states, if you need something, reach out to me. I'm part of a network of attorneys all over the United States. So all the time, people will call me and I'll say, okay, I'll find you a Michigan attorney. I'll find you an Indiana attorney. We know people that you can trust, that you can go to. So thank you guys. God bless you all for listening to me. Let's move on to the next speaker.
Well, and now you have a real treat. When you are facing your loved one, it could be a spouse, it could be, unfortunately, it could be a child, could be anybody. When you're facing the unfaceable, which is death, that all of us want to not talk about, it is wonderful to have someone who you can trust, who can talk to you about all of the options you have, because there are many now. And so that's why we have a wonderful partner in Dignity Memorial. And Kristine is just a fabulous resource for any of you. Now, she's going to talk to you how all of this tragedy can be avoided by dealing with this before you get to that point, which is what Fred alluded to. Because this is a situation that every one of us is going to face, just like Fred said. And so if you would sit down and talk to someone and make these decisions now with your family, it is so much less of a problem and so much less emotional. So without any further ado, my friend, Kristine.Reed.
Thank you so much, Sheila. What a wonderful introduction. I appreciate your kind words. So I am here today just to share on a subject that we think about from time to time, usually when maybe we've encountered a death, but we rarely discuss it. And that's planning ahead for our funeral and cemetery arrangements. And choosing how we want to be remembered is certainly very personal. And there are about as many options available as the number of guests that we have with us today. So I see right now there's 215 people on this webinar, and trust me, there are that many options, believe it or not. And I feel strongly that no one should have to come through our doors unprepared, uninformed on the day that they've lost a loved one, because we're going to be grief-stricken, we're going to be very emotional, and unfortunately, a lot of families come in our doors having to make decisions during that difficult time, and they end up arguing over the details and choices. They have to scramble to gather money, and trust me, the list goes on. So here you guys see some stresses on the screen, and certainly planning for funeral and cemetery can cause a lot of stress. And if you do prearrange, that does save a lot of time, it saves a lot of stress, and your loved ones can focus on planning the details and celebrating, not so much stressing, did I make the right decision? So a survey was conducted in the last few years by the University of Washington Medical School, and they wanted to see what people considered the most stressful events in their lives. So you can see 1 through 6. These are the 6 main stresses we have, and you can see death of a spouse is number 1, and then death of a loved one is number 3. So certainly, you probably all would think that. Most people do consider a death of a spouse number 1, right? That's going to be very emotional time, but you can also see that divorce isn't far from that, and really because divorce is kind of a separation as well, even though sometimes it is welcomed or needed. So let me ask you all a question, and you can just answer this right in your head right now, is if you were faced with the death of a loved one today, maybe your spouse, maybe a close family member, maybe your child, what would you do? who would you call? Do you know who you would call? Do you have a funeral home picked out? Do you know what friend or family member you would need to reach out to? It's a question that we need to ask ourselves really daily. And I know that's probably morbid for some people, but you really need to make sure that you know how your loved one would want to be remembered. So it is a hard conversation to have, and I'm going to give you some pointers today on how that conversation can certainly be easier. Okay, you can move it to the next slide. So when you pass away, right, your loved ones, like I said, they're going to be overwhelmed with grief and emotion. And in many cases, they're going to be at the funeral home having to complete a lot of paperwork, wondering, gosh, what did my loved one want? Did they want burial or cremation? Because we never discussed it. And I've seen it firsthand. And when things are unplanned, the great deal of stress that is caused on top of an already stressful situation, it makes families exhausted and even more emotional. And I think a lot of us, we put effort into planning important events like weddings and college education for our kids or for our retirement. And we do spend thousands and thousands of dollars every year on health insurance, auto insurance, but we never discuss funeral and cemetery planning. And death, as Fred said previously, right, it's going to happen. So wouldn't it make sense for us to plan for something that is going to happen? It's good to have homeowners insurance. It's good to have health insurance in case we get sick, but we better get our funeral plans in place because it's going to happen. So next, protecting your family. That's going to be so, so important. And many of the families that we speak with each year, they make arrangements in advance and they decide to do that because the reasons make great sense. So one, planning together, it's going to avoid painful guesswork when death occurs suddenly and your mind is going to be clouded with that confusion and grief. Purchasing today is going to lock in today's price. It's going to protect your family from inflation in the future. And then people also prearrange just to give themselves and the people that they love a peace of mind. So it can truly be a gift to your family. So that should make sense, right? And getting started, it's super simple. And we have broken it down in just 4 simple steps: reflect, record, secure, and share. So the first step is just reflecting on what's important to you and just asking yourself, how do you want to be remembered? And when your family and friends, when they're sharing memories of you in the future, what are some things that they're going to say? How might your cemetery memorialization work? And how may it reflect maybe hobbies and interests that you've had? You know, maybe you have specific traditions and customs, maybe religious, maybe non-religious, and how might that influence the type of service you might want? So there's so many questions that you have to ask yourself. And when a family doesn't pre-plan, we probably ask nearly 200 questions when we meet with them. And generally, we're only with the family maybe 2 hours, maybe 3 hours. But think about having to answer that many questions in a short amount of time, just so, hey, we can get mom or dad cremated or buried. So next, this is a picture, you know, just as kind of a private mausoleum. So if you do choose burial or you choose cremation, right, the options even within the cemetery are endless. The options on celebrations of life and memorial services and funeral services can be unique to you. But then you have to think, hey, where am I going to end up? What's going to be my final resting place? So the options are limitless, and this is just another decision that you have to make. And if you can get it done in advance, your family isn't left to make that decision, wondering, gosh, did I pick the right burial plot? What did mom want me to do with her urn, right? Like, there's so many different questions. And then after you've made those decisions about your service, you know, the next step is to record the information. So you need to write it down, right? Don't keep it to yourself, because if you die today, that's not going to help those that you leave behind. So record your wishes, write it down somewhere, keep it in a safe place that's going to be accessible as soon as death occurs. Fred even mentioned this. Thank you, Fred, that, you know, we can make funeral arrangements, maybe make our wishes known in our will that, hey, we want to be cremated, but unfortunately, that's probably not going to come out for quite some time, and services will be long over. So let's get it written down, put it in a safe place, and make sure that we share it with our friends and our family. So the next piece I just want to touch on briefly, and I could talk about veterans benefits all day, but I'm sure we've got veterans in the audience and those that serve veterans. And first of all, just thank you so much for your service. But I do think it's important that all veterans find out ahead of time what burial benefits you're eligible for. Because I hear time and time again, and I've been doing this a long time, that a veteran's family will come to me to make funeral arrangements and say, oh, the VA is going to take care of everything. Well, I'm here to tell you that is not true. Unfortunately, they don't. They do some things, but make sure you know what you're eligible for ahead of time, and make sure that your family knows as well. So step 3 is going to be secure. And by secure, I mean that there's so many options available to cover the financial aspect of your arrangements. So I mentioned before, you can lock in today's prices, because if you wait and payments due when you're dead because you haven't made those pre-arrangements, trust me, inflation happens in our business just like every other business. And I know we've all felt, right? Gas is going up, groceries are going up, well, funerals are going up as well, but you can lock in today's prices, potentially saving thousands of dollars. And I work with families on a regular basis that they prearranged in their 50s, they passed away in their 90s, and I've seen savings of thousands of dollars. So it's a really smart choice, and there's different funding options available through funeral insurance, and it's going to allow for monthly payments, one-time payments, and even if death takes place, there's some policies that you can get that you don't have to pay a dime more. Let's say you started paying and then you die after the first, let's say 2 years, and still paying on it. There's some plans that will cover it and not make your family pay. So there's really unique plans that you can get that are suitable for you and affordable for you. And if you want to do something like that, then you need to sit down with a funeral advisor, a pre-planning advisor who's licensed in insurance in the state of Texas or wherever you might be. So some people also consider life insurance, and I love life insurance, and it certainly helps some families, but keep in mind the initial purpose of life insurance was likely to cover expenses left behind for your family and provide funds for the living. But life insurance also takes time to collect. So they're going to need a death certificate before we can even proceed with services. So we're going to want our money as a funeral home. Most funeral homes are, but if we're waiting on the life insurance, well, we could be waiting over a month to get paid or longer. So it's really not the best option to say, well, I've got life insurance to cover my funeral expenses. And then step 4, finally, is share. So I mentioned this a bit ago when I was talking about recording your wishes. Talking to your loved ones can be really difficult, but it's important that you discuss the plans you've made and keep those pre-arrangement documents in a safe but accessible place. I mentioned that already. And make sure that people know what you're wanting, where your documents are filed. We kind of joke in our business, right? The best place to put your documents are in a big Ziploc bag in your freezer, right? Because it's going to be protected. Or make sure those in your family that you want to know your arrangements ahead of time, make sure that they have a copy so they don't have to go searching and digging through your house when you've passed, wondering, gosh, mom said it was somewhere in here. And you can even go a step further by completing an appointment of agent to control disposition form. Again, that's an appointment of agent to control disposition form, which you can actually designate who can handle your funeral arrangements once you're gone, which really helps when there might be some family tensions and disputes going on. And when a family comes into a funeral home after a death has occurred, it can go smoothly, it can go not smooth at all, or somewhere in between. And if arrangements are made ahead of time, there's rarely a family dispute. If no pre-arrangements were made, there are, let's say, 3 kids and they're all disagreeing on everything. Majority doesn't rule in this case because they all have equal authority. And I know where I work, I'm going to send a family home and I'm going to tell them, you guys come to an agreement now so we can proceed to get your mom or dad to their final place of rest, or you guys can leave and you can come see me when you come to an agreement. And sometimes that can take weeks. So things can get messy if the arrangements are not in place. So like I said, arrangements are so important that you do this now because it's going to alleviate that stress. It can alleviate the financial burden. It's going to give you peace of mind, and it's really going to allow your family to celebrate your life rather than wondering if they made the right decision, and making those decisions can be so hard. So don't delay, get your arrangements in place. It's so important to have this conversation now, regardless of your age, because we do not know when our last day is here, and death is inevitable. So thank you for your time and attention, and I'll look forward to any questions.
Great.
All right. Well, I'm glad that we have lots of time because we have lots of questions for all of you. So I have written them down, the names down in a kind of in the order that I saw them anyway. So I'm going to start back at the beginning.
Jeannie,
Okay.
are you still with us? There we go.
Yeah, Jeannie, good, because a lot of them are for you.
That's
Okay, hold on. Go back to the beginning. Oh, come on. Why are you not going back?
well, she's going back to that. I'm going to just tell you, y'all, we are recording this. We record all the webinars. And so you will, you'll receive the slides you should have already received. I put them in the chat, plus they went out in the email, but you'll receive the link to the recording, which will be up on our YouTube channel in a week or two.
Okay. The first question is from John Lattimore. Palliative care is or can be done in-home as well?
Yes, palliative care can actually be done anywhere. When the person is in a nursing home or skilled nursing facility, that is a different care team that takes care of that. But outside of that nursing home, assisted living, residential care homes, home with family, it can be done anywhere.
Okay. Now, Nancy Baldwin, this is a good one, Nancy, because this comes up all the time. Can hospice care be provided for more than 6 months?
Very good question. So when a patient is admitted under hospice services, it is with a doctor's decision of, would I be surprised if my patient is not here in 6 months, if their illness continues to decline in a natural way? So in saying that, there are benefit periods. There's a 90-day benefit period where the patient is recertified, another 90-day period where the patient is recertified, but that brings us to 6 months. So at 6 months, that is then looked at by a nurse practitioner or a doctor for a face-to-face visit that goes more in depth on why does this patient need to continue services. So, and then that's monitored much more closely. So the answer is yes, if the patient is still continuing to decline from their disease process.
Okay. Next question from Joyce. Has the opiate crisis impacted pain management in palliative care or hospice care?
So because palliative care is, like I said, still billed under Medicare Part B or private insurance, that pain management a lot of times will still require you to have a pain management doctor. So it's not the nurse practitioner or the physician oversight ordering those prescriptions. It will still go under pain management and all that has been under with the opiate crisis. As far as hospice is concerned, hospice is about comfort care. So the doctors will order what is necessary to keep that patient comfortable.
Okay. Next, Kimberly says, do you just request palliative care from a PCP?
You can request palliative care. You can call companies on your own and ask for it. And then, then there's records that need to be received as well. Because palliative care is so unknown right now, or used in the same sentence as hospice, please be very specific on what you're asking your doctor for.
Okay. Hospice is covered, this is gay. Hospice is covered 100% by Medicare, correct? How much of palliative care is paid?
I can't answer that because I'm not an insurance agent, and every single person's insurance is going to be different. It's really checking with your insurance company to see what they cover.
Okay, and Jeanette wonders, what if they are 96 years old and really have no disease but are in constant pain?
She can request an evaluation at any time. Going to the primary care physician and saying, what services are out there? Can you send an order for an eval and treat? An order for an eval and treat. And then the nurse or nurse practitioner will come out and evaluate.
Okay. Okay. Now, Karen says, are there time limits for palliative care for Medicare? Like, you know, you have so many days of different categories of care. No, they're not. Okay.
You can receive palliative care for however long you need symptom management.
That's awesome. Okay. I didn't know that. Okay. Now, Fred. Carmen wants to know, how can you accomplish this process of all these documents when the person's on a fixed income?
Sometimes that's difficult. I'm not going to lie that there's some, if they're, depending on where they are on the scale, the income scale, there are legal services that are free. So like in the Dallas-Fort Worth area, we have North Texas Legal Aid that would do something like that. Some, people have these prepaid legal plans, and they provide some simple documents. We actually, our firm, we try to provide for all, levels. So I have a plan that I do for I call it my college student protection plan, or my senior citizen protection plan. These are for people that don't have a whole lot, but they just need those basic documents. So you really just need to call around and talk to attorneys and see if there's anybody that has anything like that would help. We don't do it very often, but even sometimes I'll do a payment plan with people just so that they can get the documents they need and pay it over a certain amount of time.
Okay, Doug asks, what do you do when someone passes and the legal documents you need as executor are in a safety deposit box that doesn't include you as a signatory?
That's a nightmare, and it requires you to file a court proceeding, start a court proceeding, and ask for a court order to open up the safe deposit box. One of the things I tell my clients all the time is, do not put your documents in a safe deposit box unless somebody else other than you has access to get to those documents. Because I've had this happen more than once where we've had to get a court order to get into that safety deposit box to get those documents.
Okay, next question. Is a separate DNR needed for out-of-hospital emergencies, i.e., and out-of-hospital and an out-of-hospital DNR? I don't.
Yeah, so a lot of hospitals want that out-of-hospital DNR, and some states have it, some don't. Texas has a form document that they have provided that the hospitals like to use. I don't like that document, to be honest, because it is confusing, and if it's not filled out properly, it can be a DNR, or it can be an advanced directive, or it can be a combination of both, and then it's really confusing. So the bad thing about those type of documents is you have to know how to fill them out. And if you don't fill them out properly, then it causes problems. So do you have to have a separate one? No. A lot of my clients have their own documents, and when they go to the hospital and they're told they need to fill out an out-of-hospital DNR, they'll say, no, I don't. I've got my own documents. Here's copies of everything that I have, and that's good enough.
Okay, I think you just answered this next one, but I'm going to go ahead. Texas Health and Human Services website has an out-of-hospital DNR and SDPOA on their website that requires a notary. Do you not recommend these documents?
The reason I don't recommend them is they are as generic, basic as they possibly can be. So they have, so the DNR I've already talked about, that it has complications because they write these documents to be one size fits all, and it just doesn't work. So there's issues that come up with that out of hospital DNR all the time. The POA it has the bare minimum requirements by law. And so the law says in order to have a power of attorney, it has to have this at least. Now, if you have the bare minimums, it's usually not enough. It usually doesn't have enough clarity. It doesn't have enough authority given. So I don't recommend any form documents because of the problems that can always face.
And what he's not telling you is that these banks today, especially these national big banks, they reject these POAs all the time because it happens in our office all the time. So
that the power of attorney is the biggest problem document of any documents there is. And so that's why that one has to, I always tell my clients, if nothing else, you want that one comprehensive because the financial institutions are a big pain in the rear.
okay. Heather says, I understood from a hospital personnel that there is a power of attorney that exists specifically for occasions of changed cognitive abilities. What is that called? And is that necessary in addition to a medical POA?
I'm not familiar with what you're referring to. I'll be honest. I don't know of a specific document designed just for what you just said. So I don't know. I don't know about that one. I'm not familiar with that in Texas. Other states may have something like that, but I'm sorry, I can't answer that question. I just don't know.
Okay, perhaps there is a nurse on here, because I know there's several nurses on here that could write something in the comments here so that could help Fred understand what she's asking.
I think I may understand.
Oh, good, Jeannie, sure.
I can answer. So a DNR in a hospital is different than an out-of-hospital DNR.
Right.
So anytime somebody goes into the hospital, if they're going into surgery or, it looks like they have a really serious condition, it will be asked, if you are incapacitated to make a decision, do you want to have somebody make that decision for you? So that's an in-hospital DNR, and then the patient can make that decision. Every single time you go into the hospital, you need a new in-hospital DNR. Out of the hospital, that out of the hospital DNR covers you.
So a good, properly drafted medical power of attorney will give them the authority to make those decisions in the hospital and out of the hospital if it's done properly.
Yes.
So that's why we recommend people have their own forms and not rely on the forms they have to sign at hospitals, etc., because you want something that says what you want whenever you want it, not just in specific times.
Exactly.
Okay. The next question is from John. What if you cannot update documents due to health change in person after the documents were executed?
That's a problem all the time. That's why it's so important to try to keep them current while you can, because the minute you can't, you're stuck with what you got. And so if the documents work, and I tell people that all the time, I'll have people that'll move family members from another state to Dallas, and they have out-of-state documents and they cannot do in-state documents because of their capacity. They are stuck with what they've got and they have to use it until they have problems. And then once they start having problems, our only choice may be a guardianship. But I always tell people, just use what you have as long as you can have it until you get pushed back, and then we'll go from there.
Well, that's coming up to the next question. Deborah says, we have Oklahoma documents, but now live in Texas. But my husband has Alzheimer's. Can I get the documents updated here in Texas?
Well, it depends on how far the Alzheimer's is. I mean, there's people that are on that have Alzheimer's, and I'm sure you're well aware, there's multiple stages of Alzheimer's. And so I've talked to some Alzheimer's patients, dementia patients, that as long as they can understand what they're signing, when they're signing it, and the ramifications of what they're signing, then we will look at possibly doing documents. Another thing that we look at when we do documents in that situation is, what is the family dynamic like? Is there a chance that if we update these documents so that it makes wife's life easier, that we've got kids from our first marriage that are going to cause problems? Them, no, we don't want to do that. But if it's so there's a lot of things that come into play. So I wouldn't say that just because you have a diagnosis of Alzheimer's, you say, nope, I can't do documents. Talk to somebody and you might be able to.
Good, Fred, because that's a question I get asked all the time when I'm out marketing, all the time. So I'm glad you clarified that. Okay. Now, completing documents ahead of time is best. But if someone never agrees to see an attorney to handle estate planning, then who or what entity ultimately makes the decisions and handles things, especially in the case of no spouse, only one child? If the child sues for guardianship, does that child become liable for the parent's debts?
No. Okay. So who's ultimately responsible? It becomes sometimes a nightmare, because we have situations where there's not somebody there. We don't have documents. We don't have somebody that can step in. So that's a kind of a broad question, and it's a circumstance by circumstance situation. Sometimes we have to try to get a third party, a corporate trustee or a corporate fiduciary appointed. So, it all depends. But if a person becomes a guardian, whether it be the child or anybody, that guardian does not absorb the liabilities of the ward. So it's not like, okay, I'm going to become my mom's guardian, and therefore now I am personally responsible for all my mom's debt. No, I'm not. I am responsible to pay for my mom's debt out of my mom's money. And if my mom doesn't have money, then they can't come after me personally. So a guardian doesn't automatically become liable for the person they're caring for. There's not, so that's not a fear that somebody should worry about, is that I'm going to have to take over and I'm going to be responsible for everything. No, you're not. I've dealt with that with my mom. So I'm my mom's power of attorney. I'm not had to do guardianship, but I have all of her. I take care of her. I've taken care of her for almost 10 years now. And so I had to move her from one facility to another facility, and they were coming after us because that first facility almost killed her. They almost choked her to death. And then they were coming after me for money. And I'm like, good luck. My mom doesn't have any money, and you can sue away, but she's on a fixed income. She's on Medicaid. Every penny she has goes to Medicaid. Go right ahead. And I just make sure that when I sign everything, I sign it with my name as POA, or you sign it as guardian. You just don't want to sign anything that says I'm accepting personal liability.
Okay. You basically answered this, but it's worded a little bit differently. So can a will or living trust still be done if the person is considered incapacitated?
Usually not.
Okay. All right. Now, Kristine, while working in hospice, I had a patient's family experience a funeral home closure. The prearranged plans were not honored at another funeral home. What can families do to protect themselves from this?
All right, so that's tricky, and it's tricky when it happens. So what I will say is prearrangements, like in the state of Texas, most of them, especially that are done before someone is imminent, your money goes into insurance policy. And possibly in this case, the money was an insurance policy, because if the funeral home goes out of business, you don't lose your money, right? So that protects you as the consumer, which is the great part about prearrangement. But if the funeral home closes down, or let's say the family moves out of the area, right, those policies can go with you, but it's really up to the funeral home if they're going to honor those prices, especially if it's an old pre-arrangement. Because I know there's times that I'll look at a pre-arrangement and I'll say, and I manage 4 locations, so it's easy for me because we're priced different. So a family might come to me and say, hey, you know, I want to use your funeral home. I've got this pre-arrangement that, let's say funeral home XYZ went out of business, or hey, we just moved here. Will you honor it? So I'll review it, and many times, I'd say majority of the time, I do accept it. Because for me, as a business leader, I look at it as, hey, you know what? It's an opportunity to serve your family. I may not be able to make much money on it, but if I serve you well, that's going to give me return business in the future. But I can say many people don't look at it like that. So I do personally. But if, let's say, it's going to be, I won't get much money from it, right? I may say, well, you know what? I can't serve you here just because our prices are much, much higher, but my location down the street can serve you. So we can do that, but it is tricky because funeral homes are not necessarily required to honor those prices. But most of the time you're able to take the lump sum of what was paid in and apply it to your funeral contract today. And most funeral homes are going to allow that. I hope that answered your question.
All right, Christine, what choices do we have when clients decide to change their mind on burial versus cremation, or even locations to somewhere closer to where they move to later in life?
Okay, so again, because you're putting your money into an insurance policy, that can go with you. So when you're purchasing a pre-arrangement, whether it be through a local family-owned funeral home or corporately owned funeral home, you want to ask those questions. So ask the questions. Hey, what happens if I decide to move to Washington State from Texas because my kids are going to move there, right? Ask those questions. Now, first part of the question was, refresh me, Sheila. I think I answered the second part first.
Okay, the client decides to change their mind on
Okay,
burial versus cremation. Yeah.
Okay, so if the client changes their mind and they're still living, they need to change their pre-arrangement. This happens more than I wish it did, where someone wants to switch disposition for whatever reason, but hey, they told their loved one, hey, I've got this pre-arrangement for cremation, but you know, I've changed my mind, I want burial, so just handle it when I die. Well, it's not that easy, because in the state of Texas, if we as funeral directors know that someone specifically purchased their pre-arrangement for a specific disposition, we cannot veer off that whatsoever. So that's why it's important, if you do change your mind, once your pre-arrangements are in place and you've funded that or you're paying on it, you need to physically come to us and say, hey, I want to change disposition. It cannot be done once death occurs. Now, there's loopholes and ways around that, but I know me as a licensed funeral director, I'm not going to put my license at risk to give you what you want, basically. You know, if your mom had a pre-arrangement for cremation from a year ago or 50 years ago, I'm going to provide a cremation for her. Okay.
No matter what you want. Yes, I understand that. I think, and I guarantee you there are people that think, their family members think, oh no, she didn't mean that. We'll have this done here or whatever. So good. That's good, Christine. I learned a lot there. I didn't know that.
That was a good question.
Okay. Now back to you, Jeannie. What action can I take if I don't like the hospice care? They seem to just drug mom and not treat her. I understand you can't fix the situation, but they don't seem to do anything. It is what it is, that's not an acceptable answer. If she needs a Band-Aid, I have to fight for it.
So under Medicare regulations, you are allowed to transfer to another hospice company once per benefit period. If you do not feel like your hospice company is taking care of your loved one, please call another one.
So you can do that. Okay,
Absolutely.
good. Okay, Fred, this is for you. I understand that a living trust is the best way to avoid probate. Can a living will be sufficient after death? Or
Okay.
is it better to do the living trust? And how do we go about getting that?
Okay, a living will is a misconception. So people have that term living will. A living will has nothing to do with your will. It has nothing to do with death. A living will is another name for an advanced medical directive, or a what I call pull the plug document. So people call me all the time and say, I need to do a living will for when I die. No, a living will is to decide whether you want to be on life support or not. So there's no such thing as a living will that is a same as your last will and testament after death. So a living trust is a trust, and it's called a living trust because it has certain aspects of it that protect you and take care of you while you're alive, and it has aspects of it that take care of things after you die. So a living trust is always the best way to go. Now, you need a living will in addition to that, or an advance directive or directive of physicians, whatever your state calls it, in addition to what that is, but it's not one or the other. So for instance, when we do a living trust plan for our clients, we do a complete package. So we'll do their power of attorney, medical power of attorney, medical directive, HIPAA form, declaration of guardian, anatomical gift form, designation of representative for funeral arrangements, along with the living trust and all the supporting documents that go with a living trust.
Great. Before we get too far over time, and I don't know if you guys are willing to stay with us to answer more questions, but I do want to cover the CEUs one more time and get to the last slide, which is our next presentation, before we start losing people. So
Okay.
Go ahead, Sheila. Will you go through the CEU stuff?
Sure. I hope you've enjoyed this so far. Yes, we do have 20 something more questions. So we'll do the best we can to get as many answered as time will allow. But for those of you that have to leave, you will get 3 forms from Marty in a follow-up. You will get a disclosure statement that says all 3 of us do this for a living. What you've heard us present today is all of these, we do this for a living, but we are not selling you anything. We are trying to strictly educate and that you understand that today. Okay. Secondly, do not send that back. We don't need that. That's for your records. Secondly, you will get a sign-in sheet. Please fill that out and send that back. Then the third thing is you will get an eval form to evaluate the whole the whole presentation. So please send that back. We use that. Number one, that is how you get your certificate, but also it helps us with future programs. So
Great.
Okay, that's it.
In addition to that, we're going to have a Google survey. It should pop up as you close out of Zoom today. If not, you'll get a link to that in the follow-up email when I send you Sheila's documents. Please fill that out. That helps us report back on our goals and objectives we set out when we applied for the funding to host these webinars. So please help us with that if you would. If we can advance the slide one more time, and I just want to leave it here if we can, about what our next webinar is going to be, what happens when the first spouse dies. And that will be our webinar in February on the 28th. And I'm going to turn it back over to you, Sheila. And if our presenters have time, we'd love to answer the questions. That would be great.
Okay, next, Jeannie. If a person is moved from hospice after 6 months to palliative care, will the equipment provided under hospice carry over under palliative care?
So I have a couple of different answers for this. If a patient is still alive after 6 months, it's not necessarily that patient is going to be discharged to palliative services. The patient can be discharged to palliative services if they're not declining anymore. So that's half of that. The medical equipment will be picked up because the hospice company is being billed by the medical equipment company. And you're going to be back to your Medicare Part B or whatever commercial insurance that you have. And the medical equipment will need to be reordered and validated per your insurance policy.
Okay. Now the question earlier, Fred, that you did not understand the document that she was asking about, that a hospital apparently that she has seen that a hospital has. It's the difference between a medical power of attorney versus a mental health power of attorney.
Oh, okay. Yeah, we don't, I mean, in our office, we don't deal with mental health power of attorneys. Our medical power of attorney encompasses a lot of it, so that the person can make mental health decisions for that person. So I think I don't do a separate and distinct mental health power of attorney. I've not done that.
Okay, and then Betsy, the next question says, what if they can't sign the document?
If you can't sign it, you can't sign it. You got to deal with what you got. And sometimes that unfortunately requires us to go to court and have to get legal guardianship to take care of somebody.
Okay. Fred, how many people can be medical power of attorney?
As many as you want. Typically, what we recommend is that you appoint a primary and secondary and alternates, so that you say, okay, I want child number 1, child number 2, child number 3, instead of appointing all 3 of them, and then they have to get along and they could cause conflict. And so typically you want to put them in an order of some sort, but you can name as many as you want.
Okay, Kristine, is there a national umbrella organization for funeral homes which can offer transferable pre-plannings, at least in part?
So all of your corporately owned funeral homes will offer something like that. So, I mean, I work for Dignity Memorial, so if I can say, you know, we've got locations nationwide and we do honor the transfer. So if you purchase a funeral home, or I'm sorry, a funeral pre-arrangement from me, and you move to Ohio, right, we're going to help you find a Dignity location close by that will accept your policy. It's that national transferability that we offer, and other companies do as well, such as North Star, Carriage Services, things like that.
But there's not just one big umbrella organization that does that. Okay.
No.
Good question. Okay, Fred, why do you not recommend a testamentary trust?
As I said earlier, there's no benefits during lifetime, 0, because it's part of your will, and your will is not good until after you die and after a judge says it's good. So you're putting it off till later, and you're putting the burden on somebody else to set it up after you die. Another problem I always see with testamentary trusts is they're not as comprehensively written because they're in a will. So it's within a will, and it lays out the basics, kind of like an outline of I want this trust set up, but it doesn't give a lot of specifics. And therefore it causes a lot of problems when you're trying to set it up, because there's so many unanswered questions that need to be answered when it's set up. So we have nothing but complications when we have to administer a will and set up a testamentary trust. I've just not ever had a good experience with it.
Okay, Joyce asked a question, and this is for Jeannie and Fred. Do you have to pay for subpar care? How do you protect yourself from being turned into collection agency? Or if you're keeping it from, or to keep it from impacting a credit rating? More of a medical concern versus hospice, but it can be in hospice as well.
Fred, you want to go first on that?
I mean, that's kind of that's not a simple answer. You know, if you got somebody that's not caring for you and then they're trying to bill you, quite often you got to get an attorney, and you've got to, you know, I've had to do it. I've had to go where you have to jump through hoops to deny the charges and make them prove the charges are legitimate. And so I don't want to avoid the answer, but it's just not that easy. It's just not an easy answer when you're put in that situation.
I'm gonna second that. It is not an easy answer for hospice. It is billed 100% to Medicare, so nobody would be turned over to collections on that one. But right, I don't have another answer for that.
Okay, she's got a follow-up here. An inpatient intensive rehab director of admissions doctor told a patient they had no hope and would not be successful there or anywhere else. Then the medical director came over twice to apologize and beg patient to come to that rehab. Patient was billed for all 3 doctor visits, over $2,000. The doctors will not discuss or revoke the bills. How does the patient refuse payment and protect themselves? Definitely shouldn't have to pay for the 2 apology appointments and prefer not to pay for the first appointment that was demeaning and insulting. Wow.
Well, I mean, sometimes you have to get an attorney involved. I hate to say it, but when you're in a situation like that, you're kind of caught between a rock and a hard place, and you got to deal with them. Because I mean, worst case scenario, what do? They ruin your credit because you don't pay the bill. I mean, that's really what it comes down to. They can't arrest you. They can't do anything. They can't seize your property. They can't do all that. All they can do is mess your credit up real bad. So that's why I don't do that kind of work. I refer it out to other attorneys, but I have had to send clients to people to fight medical bills.
And unfortunately, there are doctors who don't have good bedside manner. They just don't.
And we've all seen that.
Yeah, run into it a lot. There is a Medicare ombudsman. If you can go to medicare.gov and contact the ombudsman to see if there's anything else that they can do if this is a Medicare policy.
Great idea, Jeannie. Okay, Nancy says, I've heard of some hospice patients receiving care for up to a year. Is that possible?
I think we answered that there are benefit periods, and I think I answered it to her. I'm sorry. So up to a year, there are benefit periods. And if the patient continues to show decline in ability, those benefit periods are recertification. So is it possible? Yes.
Okay. For Fred, I can give your HIPAA form to a doctor, but they still say they want their own filled out. Does yours supersede theirs?
Yes, yours supersedes theirs. And I always tell people, I've got a personality that I just like to screw with people sometimes. So I'll go to my doctor's office and they'll give me their stack of forms and I'll tell them, well, I don't need to sign your HIPAA form because I've got my own HIPAA form. And it throws them off every time because they don't know what to do when you tell them you don't want to sign their form. So just sign their form, give them what they need, but I would also give them a copy of your HIPAA form.
If a person only has a handwritten document, can this be acknowledged as an official will?
Yeah, it depends on the state. Texas does allow holographic. It's called a holographic will when it's a handwritten will. And usually the law of the state, if they accept them, they require certain things to be done. So like in Texas, a holographic will has to all be written in the person's own handwriting. It has to be signed by that person. It has to be authenticated to show it was their writing. So there's just, it depends on the state.
Okay. Does a living trust need to be updated?
Yes. So a living trust, no estate planning documents are the 10 commandments. We're not going to chisel them in stone and forget about them forever. You want to always keep up to date. So one of the things we advise our clients to is every 3 years, they should come see us. Now, we personally don't charge for that meeting. So we will, to encourage our clients to come back in, and then we sit down with them and we look, has your life changed? Has your family changed? Has your family structure changed? Has your finances changed? And I look at, has the law changed? And so if there's anything that has changed in that time period, then we need to talk about, do your documents need to be updated? And so I had a gentleman yesterday that just came in. It's been 5 years. He and his daughter aren't getting along anymore, and he left everything to his daughter. And now he doesn't want to leave everything to his daughter. Okay, we got to change everything. So I told him we have to completely redo your plan because you named your daughter as your power of attorney agent. You named your daughter as this. I can't just change and amend little things. I got to redo the whole document. So it all really depends on the circumstances.
Okay. Does a will have to be recorded and filed in the courts to be recognized?
Not in Texas. I don't know about other states and what they require, but no, most states don't require that.
Okay. Now, Marty, that's all I see.
That's great.
I will say that there is I want to say, oh, wait a minute. No, but I do want to say one thing, that the form that that somebody was talking about earlier is called a MOST, and it translates the preferences in an advance directive to physicians in Texas, which is a legal document, into medical orders, which can be used and transferred to the patient. As far as I know, Texas has not officially adopted it most stands for medical orders of scope of treatment. And therefore it varies from institution to institution. Other states do use those, but we do not in Texas. And that's why you didn't know that, Fred. And that's why, yeah, a lot of people. So that answers, thank you, Michelle, because we did not know that.
Can I throw one more thing in, a question here real
Sure.
quick, or I don't know if this is I guess, a question / comment, but Fred, I know you talked about the power of attorney or the family member not assuming any of the debts or any of the responsibilities, but I know before in webinars you've talked about the problem with making the patient's or the consumer's checking account, putting your name on it.
Oh, okay.
Names on it. And doesn't that create another problem?
Yes, it does, because and we see that all the time. Okay, I'm going to be on a joint account with my mom. So my mom has an account. I'm a joint owner. You're no longer just an agent anymore. You are now an owner. And if you are co-owners in anything, then you are liable. So if mom's debt, so for instance, I am on my mom's account because my mom doesn't really have anything. She's on Medicaid, and we use the account kind of as a funnel to move money. If somebody sued my mom, they could come after that account, even though I'm a co-owner, but that doesn't open the door for them to come to my other accounts. It's just the liability and what that account is, that I'm a joint owner with my mom.
Right. Does it make any difference whether you become just a signer on the account or?
Yes.
Okay.
Yes, it's huge. And we get that all the time. They'll say, well, I'm a co-owner with my mom. Well, are you really? It depends on what the bank signs up, because the bank can sign it up as a joint account. They can do it as a signer only account. So there's a lot of different ways the bank can set it up. And the bad thing about being a signer only is that if your mom dies, you can't get access to that account. So it's frozen until it goes through probate or whatever. If it's a joint owner and my mom dies, the money is now mine, which can cause other problems if mom wanted me to share that money with my siblings, because now it's not part of her estate, it's my money. And if I share it with her siblings, depending on how much it is, it can cause a gift tax problem. So that's why it's always a good idea to talk to somebody and get some consultation on what's the best way to set things up.
Great. You all, Sheila, thank you so much for all your help putting this together. Fred, Janine, and Chris, is Christine still on? I can't see you. I'm sorry.
Yes.
Thank you all so much. It was truly, truly impressive. For all of you, thank you all for joining us. We certainly appreciate it. We will get the follow-up email out to you with the documents for CEUs and the links. And also, there's a couple of links that we posted in the chat, one for Legal Aid of Northwest Texas, and one that somebody else posted, the Texas Legal Center, which is great. Thank you for posting that. But thank you all for joining us, and you all have a wonderful day.
God bless you all.
Thank you so much.
Bye-bye.
Thank you.